live in 5, 4, 3, 2, 1.
This Honorable Court of Criminal Appeals of Tennessee is now in session.
Good morning. Welcome to the afternoon session of the Court of Criminal Appeals docket in Knoxville. I'd like to introduce the panel this afternoon. To my left is Judge Kelly Thomas from Maryville. To my right is Judge Robert Montgomery from Kingsport. I'm Norma McGee Ogle from Sevierville. Each of you will have 20 minutes to present your arguments. If you would like to save time for a rebuttal, please let me know before you begin your arguments how much time you would like to reserve. And you may begin.
State of Tennessee versus Douglas M. Ferguson.
Good afternoon, Your Honors. May it please the court. My name is Patrick Rader, and I'm with the Appellate Division of the Public Defenders Conference. I represent the appellant in this case, Mr. Ferguson. With the court's permission, I'd like to request 2 minutes for rebuttal. So we're here on a probation revocation appeal, and I'd like to review a few important background facts before I get into my argument. At the time of Mr. Ferguson's probation revocation, he was 77 years old, and he was experiencing symptoms of dementia. He was initially put on probation in 2017 based on 2 aggravated assault convictions he obtained. Those convictions were rooted in events that took place in 2015 against his neighbors, the Rosenbaums. After almost a year on probation, Mr. Ferguson violated his probation for the first time by getting into an altercation with his other neighbor, Mr. Ferguson's son, Wade Ferguson. And during this altercation between Mr. Ferguson and Wade Ferguson ended up running Mr. Ferguson over with his riding lawnmower, which resulted in Mr. Ferguson's right leg being amputated. So both of these conflicts, the one with the Rosenbaums and the one with Wade Ferguson, are rooted in Mr. Ferguson's mistaken belief that he owns both of their properties. And so after Mr. Ferguson was convicted in what I would call the Wade Ferguson case, the trial court held a joint sentencing hearing and probation revocation hearing to consider what to do about Mr. Ferguson's probation violation, and also sentence Mr. Ferguson for his new aggravated assault conviction against his son. And so obviously, because Mr. Ferguson was convicted by a jury, we're not contesting that Mr. Ferguson violated his probation. We fully concede that he violated his probation. Instead, we're arguing that the trial court abused its discretion in deciding to fully revoke Mr. Ferguson's probation and order him to serve 5 years in prison. And so that is kind of related to the argument I made in the reply brief, essentially arguing that there are 2 separate exercises of discretion that a trial court makes at a probation revocation hearing. And so our argument would be that a trial court can not only abuse its discretion by finding a violation when there's insufficient evidence of one, but also that a trial court can abuse its discretion in choosing the consequence for that violation. And I cite case law that supports that standard in the reply brief, but I don't really want to focus on that during this argument today. Our office has argued this 2 separate exercise of discretion standard a lot recently in this course, and I've argued it in the West and the Middle. I haven't argued it here, but I think it'd probably be more helpful to just dive into how I think the trial court abused its discretion. And so with that, a trial court can abuse its discretion by one of 4 ways: an erroneous assessment of the proof, a misapplication of a legal standard, reaching an illogical conclusion, or applying reasoning that would cause an injustice. And so all of these, to some degree, are applicable to this case. But I think the two most important ones would be the misapplication of a standard of law and the erroneous assessment of the proof. And so we would argue that the trial court abused its discretion in treating full revocation and incarceration as the automatic and sole consequence of the violation. The trial court merely stated that I find you violated your probation by preponderance of the evidence. I revoke your probation. And so our argument is that that's really not enough. While a violation gives the trial court authority to revoke probation, the trial court needs to put its reasons on the record, and that this is the way it treated the decision in this case really showed that trial court really only considered incarceration as the only option. And it's particularly, I think, bad because Mr. Ferguson was so old. He was suffering from dementia. He had diabetes. He has 2 stents in his heart. And all of his legal problems or his criminal history is rooted in this mistaken belief that he owns these properties. And he led a law-abiding life for 68 years. And he received his first misdemeanor conviction at 68. And then he received a felony conviction at 75. And so I think the trial court blithely, carelessly saying, you violated, therefore incarceration. I think that would be an abuse of discretion. The state in its response brief says, well, the trial court went through a more thorough analysis when it was deciding whether to grant or deny probation in the Wade Ferguson case, and that this somehow corrects its failure to do that when deciding to revoke probation. And that may be, but I still think the trial court abused its discretion because its process of analysis in deciding to deny his request for probation in the Wade Ferguson case was an abuse of discretion also because he erroneously assessed the proof there. And so the trial court either ignored very important facts or misweighed them in deciding that probation wasn't an appropriate option. The first fact the trial court ignored was his dementia, which is obviously related to culpability and especially his ability to take responsibility. Almost every witness at the sentencing hearing testified that Mr. Ferguson had experienced symptoms of confusion and dementia over the past few years. Even Wade Ferguson, his son and the victim in the assault case, conceded that Mr. Ferguson had been experiencing, what looked like dementia. But the trial court didn't, weigh this mental health issue in deciding whether probation was appropriate or not. And it was really a relevant factor because, how do we treat something like dementia? And the trial court found that he couldn't be rehabilitated. Well, how do you rehabilitate someone with dementia? You don't send them to prison for 5 years. So that's the first fact the trial court ignored in making its decision. The second fact that the trial court misweighed would be his criminal history. The trial court was concerned that his criminal history was too violent and that he was, fixated on this one piece of property, and that because of that, the criminal history had to be weighed against him. But the trial court didn't consider the fact that Mr. Ferguson led a law-abiding life for 68 years, and then in the 70s, he started committing these assaults related to his mistaken belief that he owns his property. He just doesn't remember dividing the property up. And so I think that the fact that he was a range 1 offender, first felony offense happened 75 years old, the trial court shouldn't have weighed criminal history against him for that. And if it was worried about, Mr. Ferguson committing more violent acts, the trial court could have considered Mr. Ferguson's other son, Wayne Ferguson's testimony. And he testified, I'll take care of my father. He can live with me. I'll make sure he complies. And Mr. Ferguson's trial counsel even, offered, we'll agree to put him on an ankle monitor on it and make sure he doesn't go near that property. So that's the second factor that the trial court just ignored or misweighed. And then the third fact the trial court misweighed was Mr. Ferguson's inability to comply. The trial court found that he wouldn't comply with probation, and that no modification of probation would essentially make him comply. But the proof contradicted this conclusion. Mr. Ferguson was 77 years old. He had lost his right leg. He was in poor health. And the trial court didn't consider any of that in deciding whether he would comply with probation. And Wade Ferguson even testified that his father had been unable to go up to his fence that borders Wade Ferguson's property, and harass him because he lost his leg. And so I think the trial court erred in failing to consider Mr. Ferguson's physical ability to essentially continue making trouble with these neighbors. And then also the trial court never addressed Wayne Ferguson's offer to take him in and make sure he complies and live with him away from that property. So I think that was an erroneous assessment of the proof, especially because it was based on the trial court's mischaracterization of the Rosenbaum's testimony. The Rosenbaum said, Mr. Ferguson has complied with the no contact order that went along with his probation conditions. He didn't talk to us. He didn't have any physical contact with us for that whole year. But the trial court found that Mr. Ferguson had a history of not complying because he had stood on his own property and looked at and stared at his neighbors. And so that he found that as a form of contact. I think that would be an erroneous assessment of the proof because surely Mr. Ferguson had a right to stand on his own property and look at his neighbors. But the most erroneous mistake the trial court made in all this was just not even considering Wayne Ferguson's offer to take care of his aging father, and to get him help with this, potential dementia diagnosis. And the trial court didn't even say, I've considered this, I dislike it, I don't think that would work. The trial court just ignored it and didn't address it. So I think that really was an erroneous assessment of the proof in deciding what the best consequence for this violation was. And I'd just like to address two things the state mentioned in its response brief. The state argued that the trial court was justified in revoking probation because he planned to file a lawsuit against his neighbors to try to get what he perceived to be his property back. And first of all, that's not against the law to file a lawsuit. He was just saying he wanted to go through the proper legal channels to challenge their ownership. So I don't think that should be weighed against him. And the state also argued that he never accepted responsibility. And this goes back to Mr. Ferguson's dementia and his ability to essentially acknowledge the wrongfulness of his actions.
Is there any proof record about any medical condition?
Not, there was no proof about his, sorry, what's that, Your Honor?
Was there any medical proof?
There was no proof about his mental health condition. The only proof offered was the witnesses testifying that he had dementia symptoms. And he was referred to, I think, Frontier Mental Health Institution, and they, found him competent to stand trial. But they didn't find him competent to stand trial. They had to refer him to Moccasin Bend, and then they ultimately found him competent to stand trial. But there was no diagnosis of dementia. But almost every witness, even witnesses hostile to Mr. Ferguson admitted that he just has been confused for the last few years. And there was testimony about his fixations on certain things. He would fixate on these property lines. He would fixate on telephone poles and how he believed those were killing his animals. And he was fixated on, suing the federal government about that. And so I think that the overwhelming evidence was that Mr. Ferguson, whether it be dementia or not, is confused. And I think the trial court made a real mistake in discounting that. And so just lastly, before I finish up, in State v. Mitchell, this court held that the standard in deciding the consequence for a probation revocation should be best interest of the defendant, society, and the interest of justice. And I don't think there's any way to really justify this as being the best interest of the defendant and society. We're treating someone with a mental health problem that's common among elderly Americans, and we're treating that as a criminal issue and essentially using prison as a way to deal with that issue. And it's not only harmful to Mr. Ferguson, it's also harmful to the state and society, because now instead of a willing family member bearing the cost of treating Mr. Ferguson and taking care of Mr. Ferguson, now the state, the prison system is having to bear that cost. So for those reasons, we're arguing that the trial court abused its discretion in finding that 5 years in prison is the best option for Mr. Ferguson. Thank you.
You have your 2 minutes left for rebuttal.
Thank you.
General Orr.
May it please the court, Courtney Orr on behalf of the state. I first want to address something that Mr. Rader touched on and he addressed in his reply brief. I believe both parties are in agreement that decisions regarding a probation violation and the consequences of that violation embody 2 separate exercises of discretion. And here today we are talking about the second exercise of discretion on what the consequences of that violation should be. Here, the court properly exercised its discretion when it found that the defendant was no longer a good candidate for probation and ordered the defendant to serve the balance of his sentence and for his probation violation in incarceration. I do want to take a brief moment to note that opposing counsel has mentioned several times today that the court did not consider the defendant's dementia or ignored that fact or the proof that he may be experiencing dementia symptoms in its consideration. However, on page 81 of the sentencing transcript, the court specifically says, "I've considered the defendant's confusion and his social history." The court had that proof in front of it and considered it in its findings regarding the defendant's suitability for probation. Next, I understand this court has not reviewed the record in this case as of this moment, but once the court reviews this record, you will see that the trial court was considering the sentencing in case number 70498 and the consequences of this probation violation contemporaneously. The court made findings regarding the length of the sentence and the mitigating factors and the enhancement factors in the new case before it addressed anything to do with alternative sentencing. It then turned to alternative sentencing and found, 1, that the defendant was not a good candidate for probation and should serve the balance of his probationary sentence in confinement. And then in the very next line of the transcript, the court goes on to consider alternative sentencing factors, which, yes, apply to the sentencing in the new case, but apply equally to the consideration for probation or continued chances at probation in this violation case. These considerations are not as isolated and not as segregated as I believe the defendant has suggested here today, and instead findings regarding the defendant's suitability for probation for his new conviction are equally relevant to his suitability for continued probation in this violation of probation case. And here there is substantial evidence in the record to support the court's findings that the defendant was no longer a suitable candidate for probation. The defendant had a long-standing and varied history of this property dispute with his neighbors, which had led to at least 3 incidents of violence between himself and the Fergusons or himself and his son. The court found that based on the defendant's continued obsession with this property dispute and comments that he made at the sentencing hearing, that he would continue to pursue this property dispute, that he would hire lawyers, he would try to get the federal court to change its rules so that he could continue this property dispute, that the defendant could not reasonably be expected to leave his neighbors alone or to abide by the terms of a no contact order. Further, the defendant had maintained his innocence of both assaults of the Rosenbaums. There was an assault in 2010 and an assault in 2015, which led to the probation in this case. And he maintained his innocence of his assault against his son, Wade. Failure to accept the responsibility weighs against further attempts at probation, as the court has said. And finally, the defendant here talks today, which I do not believe was addressed in the brief, that the court ignored offers from the defendant's second son, Wayne, that the defendant could live with him and he would care for the defendant. And I believe that our counsel said that Wayne lived off property. Based on my memory of the record, and I will defer to what the record says regarding these facts, Wayne lived either on the property or nearby because they had split the original 14-acre parcels of land between their family members sometime in the 1990s. Again, this is a fuzzy memory of the record. I will defer to the record in this case. But based on the defendant's continued obsession regarding these property disputes and his repeated attempts or repeated assaults in furtherance of those property disputes, the court did not abuse its discretion, properly exercised its discretion when it found the defendant could not reasonably be expected to continue to abide by the terms of probation and that he was not amenable for correction or a good candidate for further attempts at probation. There is substantial evidence in the record to support the defendant or the trial court's findings in this case. The court did not abuse its discretion, and we ask that this court affirm the judgment of the trial court. Thank you.
Thank you, General. Mr. Rader, you have your 2 minutes for rebuttal.
Thank you, Your Honor. I just want to address a few things the state mentioned. The first would be that the state is right that the trial court did consider claims of Mr. Ferguson's dementia in deciding the sentencing length and the mitigating factors in sentencing Mr. Ferguson in the Wade Ferguson case. The trial court did not consider this in looking at Wayne Ferguson's offer or whether to revoke probation or deny probation. And even still, the trial court's determination that he was only a little confused or Mr. Ferguson this didn't excuse his behavior or it didn't prove that he had lacked substantial judgment. We would argue that the proof presented weighs against the trial court's finding in that area. Secondly, the state argues that the trial court made its probation revocation findings contemporaneously to its findings and reasons for denying probation in the Wade Ferguson case. This isn't exactly true. The trial court determined first that, I'm revoking your probation. And then later on, the trial court went into why Mr. Ferguson was not an appropriate candidate for probation. But our hat doesn't really hang on that issue. Really, our main issue is that this was an erroneous assessment of the proof issue, that the trial court failed to correctly weigh this evidence. And lastly, the record doesn't support this idea that Wayne lives on the property. I think best to my recollection, but I'll defer to the record as well, but best to my recollection, Wayne testified that he had sold his portion of the property and he lived on a different road, I believe. So in addition, it doesn't make sense to say that because Mr. Ferguson is going to use the legal means available to contest a property dispute or to litigate a property dispute that he's not fit for probation. There's nothing illegal about Mr. Ferguson using legal means to dispute property lines. So I think ultimately this court should look at the trial court's weighing of dementia and essentially giving no weight to it. The trial court not considering his health issues and his age, and the trial court not mentioning ever Wayne Ferguson's offer to take him in. And best to my recollection, the trial court did not mention that. And I think this case is especially important because Mr. Ferguson is an especially vulnerable inmate in prison right now with the coronavirus pandemic going on. And obviously the trial court didn't know that at the time that the coronavirus pandemic would happen. But I think that really highlights the mistake the trial court made in sentencing someone who's old, who's very old, who has dementia problems, old enough to have dementia problems, and has all these other health problems. He's an amputee. And so we would just direct this court to look back at what's in the best interest of society and what's in the best interest of Mr. Ferguson. And we would ask that this court either put Mr. Ferguson back on probation or remand for a new probation revocation hearing. Thank you, Your Honors.
Thank you, counsel. And we appreciate both lawyers, the clerk's offices, the appellate court clerk, all of our staff who've helped put this together. These aren't the usual circumstances for a court session, but we appreciate your help and your willingness to help make this session more available to the public. Thank you very much. Mr. Clerk, will you recess court until 2 o'clock?
This honorable court is now in recess until 2 p.m.